Sean Diddy Combs, once at the helm of a massive business empire, is now facing serious legal troubles. Currently in jail and charged with sex trafficking, charges to which he has pleaded not guilty, Combs has also been hit with around 40 lawsuits accusing him of sexual misconduct, including rape and assault, all of which he denies. With a federal trial looming in May, one unexpected development came from Macy's, the largest department store in the US, which labeled him an equal opportunity predator in a recent legal filing. This stems from a lawsuit filed in October by a man referred to as John Doe, who alleges that Diddy assaulted him in a Macy's stockroom in 2008. At the time, Doe was employed by Echo, a competitor to Diddy's Sean John clothing line, both of which were sold at Macy's. Doe claims that Diddy entered the stockroom with armed bodyguards, one or more of whom struck him, possibly pistol whipping him, causing him to fall. He further alleges that Diddy forced him into performing oral sex while his bodyguards threatened to kill him. Afterward, Combs allegedly took Sean John merchandise from the stockroom and distributed it to a crowd as if nothing had happened. John Doe's lawsuit also names Macy's as a defendant, accusing the retailer of pressuring Echo executives to fire him weeks after the alleged assault, supposedly due to a multi-million-dollar deal Macy's had signed with Sean John. He also suspects Macy's destroyed or purged any records related to the incident. This week, Macy's filed a motion to be removed from the lawsuit, arguing that the New York City Victims of Gender-Motivated Violence Act, amended in 2022, does not apply to corporations. They also claim that John Doe fails to establish he was targeted due to gender, pointing to his own allegations that Combs assaulted both men and women indiscriminately. In their filing, Macy's attorney stated that Doe's claims depict Combs as an equal opportunity sexual predator. Instead, they suggest that the alleged attack may have been racially motivated, citing Diddy's reported use of the term white boy during the incident. Macy's lawyers argue that, in this context, the term boy was used more as a way to belittle Doe's status rather than as a gendered remark. Texas-based attorney Tony Busby, who is representing multiple alleged victims of Diddy, dismissed Macy's argument as novel, but ultimately meritless. Meanwhile, Combs' legal team has also filed a motion to dismiss the complaint and is pushing for John Doe to reveal his identity. It remains to be seen how this case will unfold, as no court date has been set for this particular lawsuit. However, with Diddy's federal trial scheduled for May, his legal battles are far from over.
October. What's your reaction to Macy's even being named in John Doe's lawsuit after they were accused of covering up the sexual attack?
It's surprising because if you read the body of the complaint doesn't actually allege that the individual who was victimized was an employee at Macy's. Instead, it alleges that he was in a Macy's store. He was in the back room, maybe the stock room, working as a consultant for Echo. Not sure why he'd be in the back room, but he was. And he alleges that P. Diddy, Sean Combs, comes to the back room with 3 bodyguards. One of the bodyguards apparently hits him on the side of the neck, causes him to go down on his knees, and then, unfortunately, Mr. Combs allegedly forces him to have oral sex. He doesn't actually allege that Macy's did anything prior to the event, the purported unlawful event, to cause any wrongdoing or any sexual assault or any or cause him to experience any wrongs. It's after the fact, meaning after the alleged event, John Doe goes to Macy's security and advises them of the incident, and he alleges that Macy's security essentially covers up the act. That if they take a report, they don't save it, and subsequently he even alleges that the CEO of Macy's actually went to his boss at Echo and forced them or convinced them to fire him after being employed by Echo for 7 years. So it's an after the fact type of conspiracy. It's more of an allegation of a cover up than actually doing something to harm him, which, if you read the statute of the cited in the complaint under the Victims of Gender Motivated Violence Protection Law or Act, the law applies to individuals or entities, rather, individuals or entities who commit, direct, enable, participate, or conspire in the commission of the crime. Here, again, it was after the fact. So it's surprising from a legal perspective that the complaint would be filed, but Mr. Busby is a very successful attorney. He's made a lot of money. He sees a defendant with deep pockets, and like any good attorney, he goes after that defendant with good deep pockets. What's the worst that could happen? The judge will dismiss the complaint, and that's it. So the plaintiff's attorney sees his shot, and he takes his shot.
And why do you think Macy's didn't respond earlier with a motion to dismiss? Why do you think that they waited until February?
So if you look at the docket sheet, after the complaint was filed in October 2024, Macy's was actually served about a month prior to filing their response. So they actually responded in a timely manner. There was some delay between the filing of the complaint and actual service. So there was no delay on Macy's part.
And, going into Macy's response, what is your reaction to Macy's responding by calling Diddy an equal opportunity predator, given that John Doe filed the lawsuit under the New York City Gender Motivated Violence Act or law? But John Doe also admits that Diddy is willing to attack both men and women in his complaints.
It was surprising. Usually when you're a defendant, you live by the axiom of don't harm the other defendant, because if your motion to dismiss is denied, you're going to have to work with the other defendant, and you try not to put them in a position where they're adversarial to your interests. But Macy's has taken a calculated risk that the allegations aren't enough to establish a cause of action under the statute pled. They have to show, the plaintiff has to show under this cause of action that the event or the crime was motivated by gender in some way. If you read the complaint, it doesn't really go into allegations related to animus by P. Diddy towards other men. It doesn't really suggest on its face that P. Diddy committed an act motivated by animus towards man. And that's where you get the quote, he's an equal opportunity offender. He allegedly assaults males and females. And on its face, it suggests that there was no motivation based on gender. He assaults people irrespective of gender. But for a motion like this, a 12b6 motion where the court has to grant inferences in favor of the non-moving party, which is the plaintiff in this matter, the court could very easily conclude, based on the complaint, that after the incident occurred, P. Diddy was taunting the victim. So the court may simply state that based on the taunting, the taunting could have been motivated by animus towards gender. The court may ask the plaintiff to specify what the taunts were, and then the plaintiff may supplement the complaint or amend the complaint to include details of the taunts. For example, were there derogatory comments towards the individual based on his sex? Did they imply that he was gay or homosexual? And if that occurred, they would probably survive the motion to dismiss on that basis.
And I was going to ask as well, too, given what we know now, given that response, do you see a judge dismissing Macy's as a defendant or even the complaint altogether?
The judge, I think, if he reads the complaint and applies the law in a very measured way, not expanding it, just applies the law in the way that it's written, the complaint will probably be dismissed, because the wrongdoing alleged as against Macy's is after the fact, is after the commission of the crime, not before. So the allegation is that Macy's, after the fact, essentially covered the case up. But that's not an assisting in the commission of a crime, unless you interpret commission of a crime in a very liberal or vast way. And so a judge may, but again, if the statute is interpreted in a very conservative or as written way, Macy's will probably prevail on the motion to dismiss, I think, because again, the wrongdoing alleged as against Macy's is after the fact. Mr. Busby, he kind of, in his complaint, in his response to the motion to dismiss, he says, well, P. Diddy had a reputation before this incident, and nobody should have permitted P. Diddy in a Macy's store by himself. And therefore, just the fact that they permitted him in the store, they have potentially acted in a negligent manner. But that's probably far-fetched. I don't think a court will accept that type of argument.
Yeah, I kind of agree with you there, especially given that these allegations stem from 2008. Maybe it'd be different if we were talking about 2025. Maybe that might be a little more plausible, but back in 2008, I would be interested to see if that actually would work. And speaking of Tony Busby, he also responded to Macy's response and called it a pretty novel argument that should fail. What do you make of that statement?
It was a pretty clever, unique argument made by the defendant, in that they're interpreting the statute from the date that it was enacted, and therefore, for example, before 2022, the statute applied to individuals. After 2022, the statute applies to entities and individuals. But the plaintiff is essentially the defendant, Macy's, is essentially arguing that the section of the statute which refers to the grace period, the 2-year grace period from 2022, it applies for causes of actions that arose after the date of the statute. But if you actually read the statute, I think if you interpret it as in a way that it's written, it applies to any and all causes of action that arose before that date, and then you have 2 years and 6 months from the date of the enactment of the statute to file your cause of action. So I don't think that's the winning argument on behalf of Macy's. I think the winning argument is the statute doesn't apply to the case because whatever Macy's did that was wrong occurred after the fact, after the crime, not before.
And given that, Diddy faces a number of civil complaints for sexual misconduct, given that he's in jail for federal sex trafficking, do you see these complaints getting litigated at any point, or these lawsuits getting litigated at any point? And going off of your point that you had just made too, do you see other corporations or entities using that same tactic Macy's did to kind of be like, okay, we kind of still fall under this like weird little period of that the Gender Motivated Violence and Protection Act? Do you see other entities using that same kind of defense in their argument?
Yeah. The problem with filing a lawsuit against P. Diddy is that you got to get in line. There's been many causes of action. I think there's been 30 complaints filed against him. His attorneys are probably going to move for motions to stay the cases until the resolution of the criminal matter. There's natural requests for discovery extensions due to just the sheer number of cases and the volume of cases. If you're a defendant that's a company or a corporation, you probably want to drag your feet because plaintiffs, if they don't see the money bag towards the end of the case, they may lose interest and settle for pennies on the dollar, or they just may lose interest and agree to walk away from the case.
I guess we'll see where all of this goes. Oleg, thank you so much for your insight into this. I really appreciate your time today. Before we sign you off, though, is there anything else you would like to add?
Nope. Thank you so much for having me here. My pleasure.
Thank you again, Oleg. I always appreciate it.
You too. Bye-bye.
And again, Diddy has denied all the allegations made against him. His trial is in just a few short months, set to begin in May. Reporting for Law and Crime, I'm Elizabeth Milner.